Leona, one of my guests, is host here, and she's going to mute all of you. And so that means if you have a question, just go ahead and type it into your text box, and then we'll see it, and we'll deal with those towards the end of the presentation. So just once again, my name is Diana Maier, and I'm an employment and privacy attorney in the Bay Area. And as you know, today's topic is CalOPPA and the California Breach Notification Laws. And today I have two guests with me, one who is going to talk a bit about marketing and as these laws apply to marketing, and that's Leona Laurie. And then I have Joan McNabb, who is a Deputy Attorney General at the she is a Deputy Attorney General at the AG's office in California, and she's Director of the Privacy Education Unit. And I'm going to let each of them briefly introduce themselves now.
Sorry, I had put myself on mute too so that I could keep from being a distraction. I'm Leona Laurie. I'm a marketing consultant. I specialize in the strategic use of blogs and social media. And I'm based in Orange County, but my client base is international. I don't see Joan's name here. So Joan, if you're on the line from phone, can you please identify the phone number that you've called in from in the chat window so that I can unmute you? Okay, Joan may not be with us yet then. So do you want to go ahead, Diana?
Yeah. I'm just looking to see if she sent me a text, but I don't have one. Okay, I'm sure Joan will join us momentarily, and then we can let her introduce herself, and her part doesn't come for a few minutes, so we should be okay. So welcome, everybody. A couple of words about the webinar and housekeeping items. So here we go. Okay. So the way this is going to work is that I'm just going to talk now. We have such a limited time. I really just want you to focus on the substance of what I'm saying and then what the guests are going to talk about. I will have a very extensive handout after the end of this, and I will even put in that handout things that we talk about in the Q&A. And so, you know, not to worry, just pay attention and don't feel like you have to scribble notes down. Again, if you have a question, just put it in your chat window. The first 30 minutes from 12 to 12:30 today is content. And then from 12:30 to 12:40, we're going to have Q&A. And I'm going to have a hard stop at 12:40. And at that point, if you have more questions, not a problem. You can email me, and I will have my email. Well, you all have my email address available. Also, just a note that this is the first of a bi-monthly web chat series that I'm doing. So as you can see, there may be a couple of glitches, but hopefully everything will run smoothly. And if you enjoy today's talk, then definitely tune in for more. Just a note on that, if you said when you signed up that you did not want to receive more email updates from me, then you will not be alerted to those. So you may want to change, you may want to send me an email if you want to change that. Okay, so what is CalOPPA? C-A-L-O-P-P-A, which is a part of the California Business and Professions Code. And CalOPPA requires that all commercial operators of websites or online services, so that could also be, for example, a mobile app, that collect personally identifiable information from California residents must conspicuously post and comply with their privacy policy. So they have to post their privacy policy, and the organization that's posting it has to actually follow that policy. The policy has to be meaningful. What is PII? For those of you that are not from the privacy area, personally identifiable information, or PII, generally means information that identifies someone. So it can be something that's very distinctive, where you have that information, there's only probably one person like that in the entire world, or it can be information that's a little bit more general, like perhaps a more common first and last name, but that in combination with other information can identify someone individually. The term PII for the purposes of CalOPPA means individually identifiable information about an individual consumer collected online by the operator of the website or online application that is maintained in an accessible form and includes any of the following. So I'm going to just go through a few of these. First and last name, a home or physical address, an email address, a telephone number, a social security number, and so on. The requirements of the Act. So what does the Act require of you in terms of this, in terms related to the privacy policy? So the privacy policy has to be distinctive and easily found. Generally, you're going to want it on your home page with some kind of a, either, you know, on your top bar on your page, or maybe down at the bottom of the front page of your website, but something that people can easily see and link to. It has to detail the kinds of information gathered by your website, and particularly how that information is shared with other parties. It also must say how users can review the information to make changes to it, and it has to have the effective date of the policy. Once the policy is updated, then you have to have that you have to have that new date, and you have to say what has changed on the policy since the last time you drafted the policy. Then, more recently, there were amendments to this Act. This Act isn't so new, it's actually more than 10 years old, but there are amendments to it that were just made last year. The requirements now state that you also must say whether your site, for example, responds to do not track signals. So do not track signals are things that a browser emits to tell, for example, a website, I don't want you to place a cookie on my site. I don't want you to be tracking my URL or my identifying information. And what the law does not require is that you respond to the do not track, but it just says that you must state whether you do or you don't. So the idea is transparency. The other thing that the amendment included is that you have to say whether the owner of the website allows third-party tracking. And so, for example, one thing I like to do in privacy policies I create is actually say that. I mean, most people these days, for example, use Google Analytics, and then I actually will link to any third party's website privacy policy. So I'll actually link to Google's privacy policy. The last thing I want to say about CalOPPA here is that there is a 30-day notice requirement, and this is really important. So what this says is that, say, for example, the Attorney General gets wind of the fact that your entity does not have a privacy policy up. The Attorney General will contact you, and you have 30 days to cure before the Attorney General will undertake any kind of action. So that's actually a great thing, and means that most of the time these things actually do not end up in court. Enforcement is not necessary. And now I'm going to ask some questions to Joan that I discovered as I was going through this. Leona, can you check and see if we've got Joan now on the line with us?
I don't see her. So Joan, again, if you're called in from a phone number versus connecting from something where we'd be able to see your name, please identify yourself in the chat so that I can unmute you. Otherwise, you may want to just go ahead and speak on her behalf, Diana, because you've got the information.
Yeah. Okay. So I'm going to do that until, Leona, you'll interrupt me if you hear from her. This is unfortunate, but the nice thing is that we did a practice run through, and so I know essentially everything she is going to say. Maybe I could even get a job with the AG's office just move this over here. So here's what I asked her. Here were sort of my top few questions, and here's what I asked her. So I said, first of all, how does the Attorney General find out about these websites? Do they go online and start browsing sites and trying to find out, or do they get complaints from consumers, or what happens? And what Joan said is both ways. So the consumer, sometimes they will just be browsing sites for whatever reason, maybe in their personal life even, and they notice that a site does not have a privacy policy. Also, they will receive a lot of complaints. And so it's really both ways. Here's the other thing that I asked Joan. I said, does anyone who, like, for example, on my site, I don't generally take a lot of information from people on my site, really not at all. But I do have a contact form, so people can contact me on there. They can email me. And obviously when they email me, they're usually sending me their first and their last name and at least an email address. So I said to Joan, do I qualify? Do I need to have a privacy policy? And she said, yes, absolutely. So, think of this law as pretty broad-based. And basically anybody that's got a forward-facing consumer site, front-end consumer site, website, is going to have to comply with this.
And Joan has joined us, so I think she can start speaking for herself now, Diana.
How'd I do, Joan?
I'm very sorry. I had this down as 12:30.
Oh, no worries.
So here I am. You were just asking about whether a site that simply collects contact information would be subject to CalOPPA. Is that what you were asking?
Yeah, like even if it's just, say, a form to email someone and the site itself doesn't take information into, doesn't, have an intake or a credit card input or anything like that.
Yeah. Okay, so first let me give my disclaimer. I'm not giving any legal advice or rendering legal opinions. I am the educator part of the Privacy Enforcement Unit in the Attorney General's office. So the definition of personal information in CalOPPA is pretty broad, and it includes name, email address. So even if you were just collecting that, that would meet the definition.
Okay, great. Thank you so much, Joan. And let's see. I have quite a few questions here. What do you think the percentage will be in terms of private versus government enforcement for this law?
It'll be mostly government, mostly public prosecutors, because it's enforceable through the Unfair Competition Law, Business and Professions Code 17200, and that requires for an individual to have standing, they have to show monetary or property damage. And that can be very difficult in a CalOPPA case. So it's mostly going to be the AG, district attorneys, and we can enforce it for injunctive relief. And also there are civil fines of up to $2,500 per violation. And so per violation, depending on, that might be measured by how many people were, used the site when it was out of compliance, for how long. You can come up with some very big numbers.
Great. That's really helpful. Joan, I assume with this 30-day cure that you have very few cases where you actually have to bring an action to enforce this against someone. Or do you?
That's right. That's right. The law allows a 30-day right to cure. So the way we generally proceed in CalOPPA cases is we will write a letter. Although our first one we initiated when the unit was brand new in 2012 with a tweet on the Attorney General's Twitter feed that said, "Great app, United, but where's your privacy policy?" And they got one real fast. Since then, we haven't gone back to Twitter as our message, as our means of delivering the message. We'll send a letter. We'll explain what the concern is and what CalOPPA requires, and it's usually going to be that we don't see a conspicuously posted privacy policy, or it could be that a practice that we can see is out of line with the privacy policy, and then we ask to hear how you're going to come into compliance or why you think it doesn't apply. And in almost every case, we get a very quick response, and that's good. We're happy. We want to get to the good result for consumers.
Great. And Leona, let me ask you, I mean, you're a marketing expert. I know one of your big things is you do websites, and maybe Joan can shut her ears here, but how much are you actually, I mean, do your clients say, I know I need a privacy policy, or do you advise them they need a privacy policy?
Honestly, this is something that my relationship with you has brought further to the forefront of my thinking with my clients. My understanding, and you can correct me if I'm mistaken, is that as a third-party vendor, as an advisor to the ultimate owner of any of these websites, I don't have a legal obligation to alert them to this need or make sure that it appears on their site, but that it's something that I can do as a best practice. You know, if they're turning to me as their guide into the internet and they're trusting me to know more about it than they do, which is typically the case with my clients, this is part of my professional responsibility. This is a best practice for me. It's a value add to them that they can, you know, walk away from our relationship with peace of mind online. But am I correct in understanding, Diana, that I don't technically have a legal responsibility to make sure my clients have the privacy policy, that they ultimately own that responsibility? It's just something that I can do as their advocate and consultant. You're muted still, by the way.
Thank you. Okay, it wouldn't let me unmute myself. So that's what was going on. Okay, like I said, first time, everybody, so bear with us here. My understanding is that you would not have any liability. I mean, you're not an attorney, you know, and so there is no obligation that extends to you. It would be the commercial operator of the site, which you're not going to be. I would say, though, that, and I'm sure this is going to be music to Joan's ears, that, you know, it's a great practice to be telling people that they should have this up. And, you know, the nice thing about a privacy policy, I mean, I put this up on my site before I was even certain it applied to me, because I do feel like in this day and age, people are so finicky about their privacy. I mean, some people really don't care that much, but those that care really care. And I think it's a really reassuring thing for consumers. It's a great value add to let people know that putting a privacy policy on their site both makes them legally compliant and also is a great boon to showing that, you know, showing consumers that this particular entity really cares about privacy.
Let me ask you a question for a point of clarification, Diana. You said the commercial operator owns the responsibility. So that would be the site owner, you know, like the company, right? Not the host or the web designer or the people responsible for putting the site up online, right?
That's correct. Okay, Joan, Joan, do you want to say something?
That is designed to help people develop a privacy policy, to think about what they need to say in their privacy policy, both from a legal perspective and from consumer expectation perspective. And that's a document that's on our website at privacy.ca.gov. And it's called Making Your Privacy Practices Public, How Recommendations on Developing a Meaningful Privacy Policy. And when we send out our notification letters to website operators or mobile app operators that don't appear to have a privacy policy, we'll send this along with them. So we not only do we want to let them know that there's a legal obligation, but here is some suggestions on a way to do a very good job at it, even above and beyond what the law requires.
Great, and I'm going to have a link to that. Joan has sent me the link, and I'm going to have a link to that in the materials that I send you, as well as a link to the next topic we're going to get to. So I'm going to move us along here. We're already at 12:20, believe it or not. So let's talk about the breach notification law in California. So this is California Civil Code section 1789.82 is the one that applies to non-government agencies. And that law requires that you notify consumers of a breach if the following apply. You have to be a business, you have to own, license, and now with the recent amendment, or maintain computerized data. And that data has to include personal information. And if there's a breach of your security system and the data of any California resident is that's unencrypted is possibly disclosed in that breach, then you have to notify the affected individuals. And the disclosure of the possible breach or the breach and the possible leak of information must be made in the most expedient time possible and without unreasonable delay. So there's no X amount of days, because it's going to depend, of course, on other things that are going on and what kind of a breach it is. Law enforcement may have a need as well, but essentially it's got to be done as soon as possible. So again, this law is not new, but the amendments to this law are quite new. And the amendments state that if the person or business providing the notification was the source of the breach, and here I'm going to quote the exact language here, an offer to provide appropriate identity theft prevention and mitigation services, if any, shall be provided at no cost to the affected person for not less than 12 months. And so I'm going to talk to Joan about this because the if any has confused a lot of people. So is this requiring that an entity actually have that theft preventative service and provide it to the consumer free of charge? Or is it just saying that if the entity has this and they offer to the consumer, they've got to foot the bill? The other thing is that this section about providing identity theft protection only applies if certain kind of information is breached. And again, I'll have all of this in my handout, but it's got to have a first and last name or a first initial and a last name, and then some of the following, or one of the following at least: Social Security, a driver's license number, an account number along with, or a credit card or debit card along with the actual sign-in credentials, so the password, or medical information, health insurance information. So, this is very specific, kind of more highly protected information, but if this information is potentially leaked, then there is this enhanced requirement. So, again, and in my handout, I will talk about how does the notice need to be given. Joan, my questions to you are this. In this age of data, what does it mean to actually own or license? Is that, is that in privacy speak, is that the equivalent of the data controller or somebody who can take an action based, using the data? Or is that a more narrow definition that might mean like a Facebook or something like that, whose main currency is information?
Well, in the breach law, where this term owner or licensee is used, there isn't a definition, but the law uses two terms that it kind of makes it juxtaposes, and they have different responsibilities. So I think we can kind of deduce from that what it might mean. So there is the owner or licensee of the data, who, if his or its system is breached and the data has been acquired by or reasonably believed by an authorized person, has this obligation to notify individuals as rapidly as possible. Then there is an entity called a maintainer of data, and if the maintainer's system is breached, the maintainer's obligation is to notify the data owner immediately. So in many situations, it's kind of clear how that would work. So, for example, if an online merchant or a company that operates online has a web hosting company, I'm not aiming this at you, Leona, has a web hosting company who maintains the website on behalf of the company, then in that situation, it would seem like the the data that is collected through that website is owned by the company, and that it is maintained by the web hosting company. So if the web hosting company experienced a breach, that is a breach in the website, in the system of the hosting company, in this hypothetical, the hosting company's obligation would most likely be to immediately notify the owner company, the company who owns the website, who owns the data, who receives the data from the website. That company would have the obligation then to notify individuals. Now, in practice, the way that the owner would prepare for that situation, there's sort of a couple of things the owner should likely do to deal with that eventuality. And one is in the contract with the hosting company. This could be any other kind of service provider as well, who's maintaining your data for you. Require that this service provider use appropriate security to protect the data that meet the same security standards that the owner has for itself. Is this still working? Are we still working here?
Yes, somehow one of our
Okay.
guests shared their screen for a moment, but it looks to be
I wonder what
resolved.
was happening. So one is to contractually obligate the service provider to use appropriate security to protect your data, and use some due diligence in selecting a service provider. And the second thing is to contractually provide, and there's actually a law that requires you to have that kind of relationship. It's in Civil Code 1798.81.5 about security requirements for your service providers. The second requirement would be to speak to the eventuality of a data breach, and and what obligations you the data owner impose on the service provider. So it may be that if you would provide that if there's a breach that happens in the service provider system, that the service provider would be responsible for paying the costs of notification. That's often part of a contract. So there are other situations where it's not as clear who's the owner and who's the maintainer in a complicated network like the payment card data system. You know, that's very complicated. The main purpose of the law is to ensure that the individuals whose data was breached are promptly notified, and the parties involved can sort it out among themselves.
And Joan, do you read the law as requiring all businesses when those specialized provisions where you've got, say, a driver's license number and a social security card number, when that's leaked, do you read the law, and how do you read the if any language? Do you think that applies to?
Yeah, I understand your question.
Does it require businesses to take an affirmative action to provide identity theft?
So first, one little clarification. That provision applies to an even narrower set of data than applies only breach of social security number or driver's license number, because those are the types of data that are most likely to be used to open new accounts. You can't do that with just a credit card number. And that's what those protection services mostly address. So I'm aware that there's some see the language as ambiguous. And let me first speak as a former English teacher from my position of great authority on syntax. The location of the if any clause indicates that it modifies what comes right before it, and that is if any appropriate services are available. And if you read the legislative history, you read the committee analyses when that bill was going through the legislature, AB 1710 in 2013, or 2014, you will see that that's the way it's described in the legislative history, that it's described as meaning if services are available, then you must provide them if appropriate services are available, then you must provide them for 12 months at no cost. Now, this, we'll see. In general, it's become very much a standard to provide such services, and nearly any company is going to be in the position of wanting to make good to their customers, but it's only this certain type of breach where they're even relevant. you can read more on that point and on the way the services work and what the practices have been in our breach reports, which we also publish on our website. And there was one published in 2014 that has a lot of information on that topic.
So you do read it as applying that it does require a business that has that kind of a breach to cover their consumers' identity.
That's the safest understanding, particularly from a customer relations perspective.
Right. So it's almost 12:32 here. So couple more things on housekeeping I didn't mention. Then we're going to go into Q&A because I know some people will probably be dropping off now. The next online web chat I'm going to do will be in September, and that will probably be on contractors versus employees. And then again, hopefully with an expert, maybe from the Labor Commissioner's office, to talk about how these things actually work in practice. There will also be a recording of today available, and I can send you a link to it, or it'll be available on my website if you want to take a look at this or share it with anybody. Now we're going to go into the Q&A. Again, if you can type a note into your chat bar, and then we will take those questions until 12:40, at which time, if you have more questions, you can just shoot me an email.
I just want to point out, in case you haven't found it, for everyone who's on the call, if you move your cursor over the Zoom meeting window, a menu will appear at the bottom of the screen that includes the chat tool.
Leanna, do we not, because if we don't have questions yet, I can go through some additional questions that I have, and you can just let me know.
We do have one. EAH asks, please elaborate on SaaS providers. Who is the data owner?
So SaaS would be software as a service. Who would be the data owner? Do you mean under this law or generally? Both. Okay. Jen, do you want to answer that?
No, okay. No legal opinion. So if the service provider is within the software holding the data that on behalf of the customer who uses the SaaS product, seems most likely that the SaaS provider would be in that relationship a maintainer, and and their customer, the company whose data it is, would be the owner.
Okay. Okay. Any other questions yet?
I've got one. There was something that you said a little bit earlier that made me think that web designers, the web hosts. So during the breach notification portion, you were talking about web hosts and the benefit of having a contract with customers that explains the breach notification stuff. So let's say, for example, like one of the contractors that I work with does managed WordPress hosting for dozens of my clients. So if her system was hacked and the data that was in there was breached, would that be her responsibility, or would that still belong to all of the site owners?
Got to unmute her, Leona.
Oh, I didn't realize Joan was answering. Sorry, I was asking you.
Oh, sorry.
Okay, sorry, Joan.
Oh, okay.
Now you can talk.
Okay. Not giving a legal opinion, that raises the issue of subcontractors, right? so the clear, somebody who's got a clearer role as a data owner is the company who is using the hosting service, and then that hosting service may have a subcontractor. Is that the way you're posing it?
Well, the case that I was thinking of is the hosting company. If they've got all the servers and they're the one who's been hacked, then, would it be the site owner who owns the responsibility to alert people, or what you said, that the host would have to alert the site owners and the site owner would own the responsible for alerting the customers?
If we assume that the host is a maintainer under the law, then yes, that is the obligation. Where that changes, how that actually plays out, it is the owner, in the terms of the law, should have contractually obligated the site owner to not only notify them, which the law requires anyway, but potentially and to bear the cost of the notification if the breach occurred in the maintainer's system.
You unmute. Oh, Jen, I have another question for you too. The CalOPPA applies to collecting information from any California resident. So it could really apply to a website anywhere. I was curious how much this gets enforced outside of California, or a mobile app for that matter, anywhere.
Yeah. Well, as in the case of many California laws, when you can establish a sort of nexus of relationships to California from a company that is physically located in another state, it's still subject to California law, and we have pursued, and certainly in CalOPPA case, sent notification letters to companies in other states. Now, it's not clear, just, it kind of depends on how egregious the case is, et cetera, whether we would pursue it all the way. But with CalOPPA, we've had such success in just getting compliance by letting them know.
Right. Well, guys, we've got about a minute left, and I don't see any more questions in our chat. Am I reading that right, Leona? You can just nod at me. Okay, good. So I'm going to let everyone go. I want to just thank Leona and Joan both so much for the, participating, and, Joan, you in particular, I know how busy you are, and I know that this was a leap of faith. So I really, really want to just tell you how much I appreciate your being here today, and I know everyone else appreciated it as well. And thank you so much. And again, if you have more questions, you can email me online at Diana@dianamaierlaw.com, Diana@DIANAMAIER law.com, or call me at 415-515-1707. Thank you so much to everybody for coming.
Thank you, Diana.
Have a great day.
Bye-bye.